HB 87. I feel like I've been here before several times. This is the much-awaited foreclosure bill. We need to give the courts the tools they need to streamline the process. The bill has 4 basic components. Number 1, for the benefit of the borrower, our legislation would shorten the statute of limitations for a deficiency judgment to 1 year from the 11 days after the date of the sale. Currently, it's 5 years. Number 2, the bill would place an affirmative duty on our lenders to provide certain documents when they file the foreclosure. Basically, it would streamline the process with the preservation of all the due process rights of the borrower. It would remove some unnecessary hearings. It would permit, well, right now on the show cause statute, only the lender can use this procedure. And it basically allows the lender to go to the court and say, Judge, there's no issue here. There are no defenses to the foreclosure. Go ahead and issue the judgment. But doesn't allow other lien holders, such as condominium and homeowner association. And as we all know, some of these foreclosures that have been languishing for up to, I think the last thing we heard was 800 days, the condo and homeowner associations have been remaining unpaid. The last thing is something that is important and has not been understood as readily, and that is protection for the third-party purchaser who buys the home after the foreclosure has completed. Someone may buy that property, and the problem that we have is that at some point, if the foreclosure had a defect in it, and more likely it's the case where there's a lender out there that has the note, but the lender who filed the foreclosure it wasn't entitled to because there's another lender out there. What we want to do is take that lender that has the note from coming back against a bona fide purchaser for value without notice of their interest and trying to basically divest them of title to the property. Any defense, such as, I know I owe the money, but I don't want to move out, that's not a real defense. That's a wish. What we don't want is a scenario now where the borrower basically, says, I know I owe the money, but I don't want to move out, and it just doesn't work.
What exactly was the need for the bill, she said? Didn't kind of hear it. That's the first thing. What's the need for the bill? We have evidence code. We have foreclosure process already. If you're dealing with that, because you read staff now, it's about how the foreclosures are delaying and moving on, but that's the judge's fault. After 1 year, he can dismiss the case for lack of prosecution. He can sua sponte, do a CMC, case management conference, today. Then you're going to try to make this bill, in the sense of violation of separation of powers, to try to make the court make new rules for something that they don't need to make. You don't need this bill right now unless it's extreme need. The sponsor stood up here. Could not explain really some of your questions. Well, okay, how this is supposed to work. No, I don't want to know how it's supposed to work. This is your bill. How does it specifically absolutely work? The court will confine and construe it strictly. The rules in this statute will be followed strictly. How does it go, member? Well, how it's supposed to work is no, not how it's supposed to work. People's license on the line and their property. How is it work? Absolute. End of story. She could not answer questions. I don't want to hear suppose. Tell me end of story. This is a TV deal for us. I'm concerned, Mr. Chair, but thank you very much. No, you're not ready for this. You need to talk to the judges.
There are not nearly enough lawyers who comprehend what are cognizable defenses, meritorious defenses, and how to represent people. And then there's no mechanism to pay the lawyers. So there's zero incentive for lawyers to help people that have meritorious defenses.
What happened to the money she borrowed?
Well, it is allegedly most of it was supposed to go off to pay another small debt, but there was over $9,000 in closing costs on this little refi for less than $70,000. So a lot of that money went into to line the pockets of mortgage brokers who have already been cited by our own Department of Revenue as breaking Florida's laws regarding lending.
We have special foreclosure courts to make sure that the foreclosures move quickly. They still don't move quickly, and the courts don't know why. In Duval County, if there are no defenses filed or if there's a default, you can get a judgment within 2 months of filing the lawsuit. But in October of last year, our chief judge sent out 2,400 notices to plaintiffs' attorneys because they had not been moving their cases along, and their cases had been sitting for 2 years with them doing nothing. We do know that the servicers have been proven to be the cause of delay. The investigations by the Attorneys General of 49 states and the Office of the Comptroller of the Currency showed that faulty paperwork was involved in the majority of foreclosure cases, and servicers were not doing what they were supposed to do to try to consider loan modifications, loan reinstatements, short sales prior to the filing of the foreclosure process. And in fact, they have now put their feet to the fire and said that you must do this. There's an Office of Compliance that gets complaints every day because the servicers are still not doing the required pre-foreclosure default servicing, and the faulty paperwork is still being used. Shouldn't we be making sure that the servicers are doing what they're supposed to do before they file the lawsuit to make sure that foreclosure is necessary? We have thousands and thousands of homes that are just sitting empty. The thing that we do know for certain is that the process is rife with false and fake documents. And so if you're going to base the initial decision as to whether the borrower may go forward on just the paperwork itself, then we've sort of ignored the whole problem recognized by the OCC and the Attorneys General, that the paperwork is the problem.
Very briefly, the Florida Chamber of Commerce understands that improvement to Florida's overall economy is at risk as long as there's such a high number of existing and potential foreclosures dragging the housing market down.
I also question why there are over 10,000 cases in Palm Beach and over 1,800 cases in my county, which is Charlotte County, a rather small county, where the banks have won their cases more than a year ago, but they have not taken ownership of any of these properties. The preventing of someone to get their property back when it was fraudulently taken has bothered me the most. This brings up the question of why anyone would attempt to implement such a bill restricting someone getting their property back that was taken by fraudulent means. Who has the most exposure to risks associated with these known frauds? It comes down to title companies. They have insured these properties' titles knowing full well there was significant risk, but they miscalculated and thought it would not be exposed to the extent that it has. These same title companies and insurance companies contributed to various political campaigns for elections, including the sponsor of this bill, to help ensure that such legislation gets passed to close the door on their liability. They count on your willingness to help cover up for their criminal actions of the banks and their attorneys. They are counting on you to push the courts to continue focus on speed rather than legitimacy of court cases.
We know now, by virtue of all of the government enforcement actions, all of the settlements that have taken place, all of the consent decrees, that a substantial number of foreclosures that have taken place in recent years were effectuated by fraud. And so we're concerned because HB 87 threatens to increase that number because the bill places expediency over the due process rights of homeowners.
Why aren't the banks taking title when they hold summary judgment? The answer is easy. They don't want to own units in condominium and homeowner associations. They don't want to pay the fees. They want to be protected by what's called the safe harbor cap, which is 12 months of assessment, so they sit on it until they can short sell it. And this is causing tremendous burden.
The relationship between the borrowers and the lenders that begins way before it reaches a foreclosure is something that the state of Florida does not regulate. The relationship between a borrower and a lender is regulated by the federal government. The federal government regulates the banks. We do not interfere in that contractual relationship. If we were able to, we probably wouldn't be here because Florida, unlike the federal government, gets things right.